Now, just about the time that the Audio Home Recording Act was beginning to be implemented, another technological development needed a regulatory attention: digital broadcasting or transmission of music over internet. A number of online services were beginning to stream music as a subscription and non-subscription service, interactively and non-interactively. And while some of this activity was clearly a form of broadcasting for which the composers and publishers were due their performance rights royalties according to the Copyright Act, the labels and the recording artists were not getting paid, also according to the Copyright Act, which, as you remember us talking about in one of our earlier modules, did not allow for the performing rights royalties for the sound recording copyright owners. Now, the reasoning behind why the sound recording copyright owners did not have performance rights in the first place was officially because the public performance, like radio broadcasts and playing of the recordings in the public places, increased the popularity of those recordings and boosted sales. But digital online streaming is not like that, the labels argued. It was perfect copies of the original available online, interactively or non-interactively, and it would adversely affect the sales of the recordings as they could fully replace the need to buy the original. Just like was the case with the consumer-type digital recorders, and because of which the Audio Home Recording Act was created. So another act was needed to remedy this new situation. That act is 1995 Digital Performance Right in Sound Recording Act, or DPRA for short. The act amended Section 106 of the Copyright Act dealing with the performance rights and added the right of the public performance to the sound recording copyright owners, but only by means of digital transmission. The Act defined three types of digital transmission in relation to these rights. First, the interactive digital transmission services. Those services where the user can choose the music they want to hear. As we discussed in our module on the sound recording licensing, those licenses are not statutory, must be negotiated directly with the rights holders, and can be refused. Second, the non-interactive subscription-based digital transmission services. Those services that collect subscription fees and where the music content cannot be modified by the users. Those licenses are statutory, could not be refused, and if the parties could not agree on the licensing royalties rates, then the Copyright Arbitration Royalties Panel would make a ruling. And third, the Act specifically exempted certain transmission services from the requirement of the sound recording performance rights licensing, particularly the non-subscription broadcast transmission services. So what does this mean? Well, depending on whom you asked at the time. See, the radio broadcasters interpreted it to mean online transmission, or webcasting as it was referred to, of their terrestrial broadcasts. That because they're not liable for the sound recording performance rights royalties for their terrestrial broadcasting, they should thus not be paying labels for digital versions of those terrestrial broadcasts either. So they didn't pay labels for their webcasts. Labels, on the other hand, interpreted this exemption category to mean exactly and literally what it says: non-subscription broadcast transmissions, not non-subscription digital broadcast transmissions, meaning over-the-air broadcasts are exempt from the licensing, not webcasts of over-the-air broadcasts. But the broadcasters would not budge and refused to pay the labels for their webcasts. The labels appealed to the Copyright Office for the opinion and ruling, and the Copyright Office itself agreed with the labels that the DPRA's exemption is meant for over-the-air broadcasts and not for the webcasts of those broadcasts, that all the online transmission of the sound recordings have to be licensed and royalties paid. The broadcasters still didn't budge and continued to refuse to pay the labels for the webcasts. Also, to make things even more convoluted, the language in the DPRA didn't make clear what kind of sound recording licensing, if any, is required by the non-subscription webcasters in general, other than the radio broadcasters. Their service was non-interactive and free, but they used and transmitted copyrighted digital sound recordings. And they didn't neatly fit into any of the DPRA-defined licensing categories. So before the ink was dry on the 1995 Act, another act was in order to clear things up about these and other issues which muddied the waters. Digital Millennium Copyright Act, or DMCA, was signed into law in 1998 and extended and strengthened both the 1992 Audio Home Recording Act and the 1995 Digital Performance Right in Sound Recording Act. It includes a number of provisions crucial for the music industry business and operations. For instance, it makes it illegal to circumvent digital copyright protection measures, like the serial copy protection systems required by the 1992 Act. It also prohibits the manufacturing and distribution of the hardware and software devices that are designed to enable circumvention of such copyright protection systems. Also, the copyright management information, or the CMI, is protected under the DMCA, and altering it is deemed illegal. CMI is the information about the authorship, title, conditions of use, and so on regarding the copyrighted work which accompanies the work. Another provision of the DMCA that affects the music industry greatly is that internet service providers are relieved of the responsibilities for the copyright infringement actions of their subscribers if the providers comply with certain procedures of informing, warning, and so on the infringing subscribers of the infringement they are committing. This so-called safe harbor provision has a deep impact on the industry today, as illegal online services that continually infringe the music copyright are operating using the ISPs, which are deemed not responsible for what their subscribers are doing, no matter how illegal it may be. Meaning, if an ISP simply complies with the administrative requirements of the Act, it can continue hosting and continue collecting service fees from any and all illegal copyright infringing entities using their service. You be the judge if this is conducive to digital music business and music copyright management, or to any digital business that includes copyright management. The DMCA also provides for the licensing of the ephemeral recordings that we spoke about in the module on the sound recording licenses, those temporary copies of the original recordings on the server's hard drives, for instance, that are used for creating the playlist for various broadcasts and transmissions. And finally, that webcasting issue we talked about that was left undefined in 1995 Act, the DMCA made non-subscription webcasting an official category for the statutory sound recording performance rights licensing. So all the webcasters who did not charge for subscriptions would from that point on have to pay statutory license royalties to the copyright owners of the sound recordings if they wanted to stay in business. Okay, so that's settled. And how about that question of over-the-air broadcasters who did webcasts of their broadcasts? Remember how they refused to pay sound recording performance rights, although the Copyright Office itself ruled that they have to? Well, since the DMCA didn't further clarify the language used in the 1995 Act regarding the broadcasters, they still refused to pay the labels for the digital transmission of the labels' recordings. The Copyright Office ordered the payments from the broadcasters, and the broadcasters in turn sued the Copyright Office in 2001 to rescind the order and to have the courts decide if they are liable for the sound recording digital transmission royalties. The case is known as Bonneville International Corporation versus Peters. Bonneville International owns and operates hundreds of radio stations across the country, and Mary Beth Peters was the United States Register of Copyrights at the time. The case was ruled against Bonneville in 2003 by the United States District Court of Eastern District of Pennsylvania, finally settling this long-standing issue. The broadcasters had to pay the labels for the digital transmission of their recordings. And so in just 6 short years, from 1992 to 1998, we had 3 major acts that amended, modified, and expanded the scope and the nuances of the music copyright in an attempt to bring it in step with the digital realities of our time and with the new circumstances in the industry. And they are still the basis for much of the music industry's business and operations today, as we didn't have any other act as critical since the MCA. The Copyright Act is still far from being able to cope with all the complexities and forces in the market today. And the courts are still asked to step in and solve the disputes stemming from the differences in interpretations of its provisions. But that will always be the case, since the copyright law tends to be developed reactively and not proactively as the technology is developed and as the market changes with those developments. What we in the industry need to do is remain active in our professional organizations and associations, stay vigilant and informed of the legal and commercial landscape, and continue educating and keeping our legislators aware of the changes and the challenges we see ahead so they can hopefully act timely and appropriately.